the number of attendees is beginning to taper off now, so I think we'll get started, and people can always come in during the course of my introduction. First of all, welcome to everybody. I'm sorry, we had originally planned for this to be at least a hybrid event, and then the resurgence in COVID meant that we still have to wait for the day when we can all be back together and discussing these issues in person. But hopefully we'll make up for that with a very interesting seminar today, which is going to be addressing some of the substantive and procedural issues in relation to the assessment of mental capacity, particularly in the context of housing cases. And in my opinion, at least, this is one of the most interesting, but also one of the most difficult areas that housing lawyers have to routinely deal with. And so it's particularly pleasing to see so many of you here this evening. And it's particularly good to see on the attendees list that we were sent, so many people here from local authorities. I certainly haven't personally done a huge amount of landlord work for local authorities in possession cases, but it's an area where I think it's perhaps most important of all that the parties are working together collaboratively. And often local authority lawyers will be the first people who are exposed to possible doubts about capacity, and indeed sometimes the only people where the tenants aren't represented. So I think it's a particularly fruitful area for discussion. We're hoping that people have come armed with many questions from their own experience, and so we'll try to keep the presentations relatively short to allow proper time at the end for discussion, because I think it would be certainly interesting for me to hear about the views and experiences of those in the audience. So in terms of the order, we're going to hear first on the substantive issues about capacity from Sophie Miles. Sophie will need no introduction to most of you. She's a Court of Protection practitioner of many years experience, and she's going to deal with some of the substantive issues that arise from the point of view of the Mental Capacity Act. After Sophie, Marie Paris, who's a member of the housing team in Chambers and has extensive experience working really on the front lines of housing work, doing duty possession work in precisely the kind of context where these issues arise. She's going to move on to deal with the more procedural questions about where capacity issues fit within civil procedure in housing cases, and how when these issues appear to you, how to go about getting them resolved and dealing with them appropriately. They're each going to speak for around, I think, 20 minutes. And then we're proposing to deal with questions at the end, primarily. But if you enter your questions in the Q&A box at the bottom, then we'll be able to see them as they're coming through. And if there's any that look particularly relevant to deal with immediately, I can put those to the speakers and we can deal with them then. So without any further hesitation, I'm going to hand over to Sophie to deal with the substantive issues in relation to capacity law.
Thanks very much, Dan. It's really lovely to be here, and Happy New Year to everybody who's here, if it's not too late to say that. Ray, can I ask you to go to the first slide? Thank you. So what I'm going to say in my sort of slot is a very brief introduction to some key aspects of the Mental Capacity Act. And what I particularly want us to be thinking about is kind of identifying the right decision. What is it that we think a person may not have capacity to make a decision about? And that, I think, is particularly important for cases that arise perhaps in a jurisdiction other than the Court of Protection, whether through a family case or a housing case. I'm then going to look at some sort of tricky issues around assessing capacity. And then I'm briefly going to talk about using the Court of Protection to resolve some of these issues. So Ray, if we can go to the next slide, please. Thank you. So Mental Capacity Act 2005, and I know there's a lot of very knowledgeable capacity lawyers in the audience, so I will try not to linger too long on this. But we've had the Act now since October 2007, and I think you can kind of distill the kind of purposes of the Act into these 4 points. So first of all, what it does is it clarifies the common law tests that had been in place up until the Act for capacity. What does it mean to have capacity? What does it mean to lack capacity? And also, how do you assess what is in the best interests of someone who lacks capacity? It also creates a statutory defence, Section 5 of the Mental Capacity Act, and that really replaces the use of the common law doctrine of necessity. It creates lasting powers of attorney for both property and affairs and health and welfare. And it also created a new court of protection with the power to make decisions on behalf of the person or to appoint a deputy. And of course, the Court of Protection had been around for centuries under various different guises, managing money. But now the Court of Protection has the power to make decisions about personal welfare as well. And it also deals with deprivation of liberty applications and appeals. So that's just a very short summary of what it does. Next slide, please, Ray. I am going to just look at the guiding principles of the Mental Capacity Act, and I'm going to sort of zero in on a couple of them that I think have sometimes been somewhat problematic. So we know that one of the most important principles is the principle of the presumption of capacity. A person must be assumed to have capacity unless it's established that they lack capacity. You're not to be treated as unable to make a decision unless practicable steps to take the person have been taken without success, and you're not to be treated as unable to make a decision because you make an unwise one. And then if we can go on to the next slide, that will just to sort of finish off those principles before we look in a bit more detail. An act done or decision made under this act has to, for someone who lacks capacity, must be done in their best interests. And then very importantly, the principle of least restriction, the need to have regard to whether the purpose for which an act is needed can be done just as efficiently and effectively in a way that's less restrictive. So it's not always going to be possible to find the less restrictive way of doing whatever it is that you need to do, but you always have to try and look for it. And that's been described as a break on the powers of the state. So if we go to the next slide, we'll look at the presumption of capacity. And presumption of capacity is obviously hugely important as a protection of autonomy for the vulnerable. But it does have limits, and I think there are times when it has caused some difficulties. Some of you will have looked at the findings of the House of Lords Select Committee that reviewed the Mental Capacity Act in 2014, and they found a number of problems with the Act and the way, not so much with the Act, but the way it had been implemented. And in particular, they were concerned about the presumption of the capacity, and they said it was widely misunderstood, and it was sometimes used to support non-intervention or poor care, leaving vulnerable adults exposed to the risk of harm. And if we can go on to the next slide, we'll see some more sort of rather more detailed guidance about sort of where is the limit of the presumption of capacity. So in this case, it is actually an employment case, Royal Bank of Scotland and AB. The Employment Appeals Tribunal stresses here the importance of the presumption of capacity, but it says this is a presumption and it has to have logical limits. And where there's good reason for cause for concern, or there's legitimate doubt about capacity to litigate, the presumption can't be used to avoid taking responsibility for assessing and determining capacity. And that, I think, applies across the board. So, if one comes across someone who is persistently acting in a way that is putting themselves at risk, it is not sufficient simply to say, well, presumption of capacity, it's an unwise decision. There is at that stage a requirement to start sort of drilling down and seeing whether in fact this is somebody who is simply not making capacitous decisions. And in that case, that leads on to potentially to the assessment of their best interests. So if I can have the next slide, please. So let's look now at what it means to lack capacity. And this is set out in sections 2 and sections 3 of the Mental Capacity Act. And we'll start by looking at section 2. So again, many of you will be very familiar with this. Someone lacks capacity in relation to a matter if at the material time he's unable to make a decision for himself in relation to the matter. So it's this matter, it's this specific issue decision that the person has to make at a specific time. And that's why we talk about capacity being time specific and issue specific. And again, that's only part of the test. The second part of the test is that the reason why that person can't make a decision is because of an impairment of or disturbance in the functioning of the mind or brain. And we're going to look at the importance of what's described as that kind of causative nexus later on in this talk. So that's what we know. If you're unable to make a decision, and the reason you're unable to make a decision is because of an impairment or disturbance, then you're going to lack capacity. But how do we know if you're unable to make a decision or not? Well, the next slide will reveal that. Thank you, Ray. So we know that someone is unable to make a decision if they're unable to understand the information that's relevant to the decision, retain it, use or weigh the information as part of the decision making, communicate the decision, and then this is quite importantly over the page, please, Ray, to the next slide. Thank you. You're not to be regarded as unable to understand the information if you can understand an explanation in a simple way. The fact that you can only retain information for a short period doesn't stop you from being able to make a decision. And I think this is really sort of relevant and sometimes forgotten, that the information that you have to be able to understand includes information about the foreseeable consequences of deciding one way or another or failing to make the decision at all. And just by way of an example, I dealt with a case some years ago with a young woman with learning disabilities, and she lived in a placement. Everyone was quite happy with the placement. It's quite near her mother, but the placement was going to close. And there were various options for P, this young woman, as to where she might want to go. And, you know, those were discussed with her. And on one day she would say to her mother, she wanted to live in, you know, option A. And then the next day she would say to the social worker, well, I'm not so sure about this. Maybe I want to live in option B. And it got closer and closer to the time at which the placement was going to close. And the local authority's initial position was, well, you know, she is making a decision, she's weighing up the options and thinking about them. But what became clear was that she didn't really understand that actually this placement was going to close on a particular date and she was going to be homeless if she didn't decide one way or the other. And so her difficulty was that she didn't understand that failing to make the decision was going to cause her a real problem. And that was the basis on which the court found that this particular person was unable to make that decision. Can we have the next slide, please? Thank you. So before we are going to look at capacity in more detail, but just by sort of way of completeness, looking at what happens if you're found to lack capacity, we've got the best interest checklist in section 4, the things that you must do where a person reasonably believes that somebody else lacks capacity, and they include encouraging the person to participate, consulting others, and there's no hierarchy, there's no presumption, it's a fact-sensitive approach. And when we look at the appellate courts, and what judges have said about the application of both capacity and best interest tests, they're all very keen to say, look, just do what the Act says on the tin, follow what the sections 2, 3 and 4 tell you, don't try and add presumptions or starting points or glosses on the text. And that's a consistent message that you get from the higher courts looking at the operation of the MCA. So if we could just quickly have section, the next slide, please, Ray, section 5, and this is the common law duty of necessity. If you take reasonable steps to establish whether someone lacks capacity to make a decision, you reasonably believe they lack capacity, you've gone through the best interest checklist, and you're reasonably of the belief that it's in the person's best interest for the act to be done, then you have a defense to carrying out an act of care or treatment. That doesn't apply to anything to do with property and affairs, just care and treatment. So let's move on now. And we're now going to go back and drill down a little bit into some of the issues arising in capacity assessments. And very fortunately, we've just had the Supreme Court look at the whole question of capacity in the case of a local authority and JB. And they've told us that, in fact, a lot of the time we've been approaching it in the wrong way. What the Supreme Court has said is you have to do is, first of all, you identify the correct formulation of the matter. What is the decision that the person is supposed to be unable to make? And then you've got to identify the information that's relevant to that decision. And you look at that in the specific factual context of the case. So you look at, you're not trying to look at a decision in the abstract, you're looking at the particular decision that this person has to make. And as the Supreme Court pointed out, that may very well help you work out how you're going to help that person make the decision. When you're identifying the relevant information, you're looking at the consequences for that person. So P must understand the consequences of a decision for them. But what the court said in JB is also that it may be necessary for that person to understand the consequences on others. So, for example, the consequences of antisocial behaviour or the consequences of assaulting somebody. The Mental Capacity Act doesn't just protect the best interests of P. Next slide, please. So let's think about, the kind of decisions that the court that you might think a person who's in a housing case may not be able to make. Can they make decisions about where to live? What about decisions about their care needs? What about decisions about managing their property and affairs? What about decisions about removal, clearing their property in the cases of people who have hoarded and put themselves or their neighbours at risk? Can they make decisions about the removal of those possessions? Can they make decisions about complying with the obligation of a tenancy? And so once you start to sort of drill down to the question, the specific question that you want to answer, you're going to be much better placed to ensure that a good assessment of capacity takes place. So if we can just onto the next slide, please, Ray. Now, there's a sort of decisions come in sort of shapes and sizes, and we take some decisions that are big one-off decisions, and others are ongoing. And if you've got an ongoing task, then you might need to make decisions at any time. And therefore it follows that if you're someone whose capacity may fluctuate, you're less likely to have capacity to make a decision that requires ongoing input from you. So, for example, managing money, and I've put the authorities here on the slide. Managing your money is a continuous state of affairs. You don't know when you're going to have to make a decision about the money, and you might have to make it really urgently. Another example from a case called Royal Borough of Greenwich and CDM, managing diabetes, that's a global decision. You have to make several different decisions at different times, such as, what your diet is, testing your blood, administering insulin. So for those whose capacity fluctuates, it's less likely that they're going to be assessed as able to manage money or manage diabetes, because that requires ongoing decision making. So I hope that is helpful. So can we go on to the next slide? And again, go back to what the Supreme Court has told us to do in JB. So step 1, assess whether P is actually unable to make that decision using the test in section 3. And then, and only at that point, you have to ask yourself whether the reason why the person can't make that decision is not because they're anxious or nervous or under the influence of somebody else. It's got to be because of the impairment or disturbance in the function in the mind or brain. And I think it's worth noting that sort of quite a lot of pro forma documents actually approach that test in the wrong way, or in the wrong order. Because they ask you to look at the diagnostic issue first and then look at the ability to make the decision. So just be aware of that. And then if we can turn to the next slide, please. So how the impairment and disturbance obviously doesn't need to be permanent, and people can be lacking capacity because they're intoxicated or concussed. And a lot of decisions in medical treatment cases have to be made at a time when someone may lack capacity because they're unconscious or in a coma. But when you're talking about longer term conditions, there's a huge range of conditions that might influence the way in which people approach decision making. And in some cases, they are disorders like dementia, where in many cases, it will affect your decision making across the board. But that's not always the case. There are some disorders which may affect your decision making in one area, but not in others. And so, for example, I've just given a reference for a case called RE, medical treatment, about a young woman with anorexia. A highly intelligent woman, had able to make a range of decisions, but when it came to decisions to do with nutrition and hydration, what the court said is the fear of calories is the card that trumps all others, and it prevented her from making decisions about nutrition and hydration when she could make decisions about all sorts of other aspects of her life. So that's sort of one of the things that's really important to bear in mind. I've got a couple of cases involving people who were hoarders, which we'll look at on the next slide, and we can see how the court approached these. So a case called Lincolnshire County Council, JK, the woman with dementia who'd been living in sort of really appalling conditions. And the judge found that the dementia prevented her understanding the risks that she was posing to herself by living in those conditions. CDM, again, P had a personality disorder and again was living in appalling conditions. And the judge found that her inability to acknowledge those risks was a direct consequence of her personality disorder. So 2 very different conditions, both impacting on the ability of someone to decide about their living conditions. And then the last few slides are about just using the court of protection. I think I sometimes hear people sort of talking about transferring cases to the court of protection from other courts. You can't do that. You need to make a specific application to the court of protection. It's a superior court of record. Has the power to make declarations and also to make the decision for P by making an order for them or appointing a deputy. Also has the power to deal with certain deprivation of liberty appeals. We don't need to go into that today, but it's always worth remembering what the limits of the court's power are. The court can't make a local authority provide an option or pay for something or commission something. It can only choose between the options that are genuinely available. And again, that's a Supreme Court case, N and a CCG. So why might you go to the court of protection? Next slide, please, Ray. Well, you might go to the court of protection because you simply don't know the answer. And it's a really helpful comment by Mr. Justice Peter Jackson in the Neary case, where he says, well, sometimes you're going to know exactly what you're proposing. You go to court asking for a specific order, but you might not know. And if you don't know, in a difficult case, it's no shame to say so. The proceedings need not be adversarial. Next slide, please. A reminder that most applications in the courts require permission. The grounds for permission are set out Section 50. And it's always worth remembering, trying to sort of familiarise yourself with at least some of the Court of Protection rules. They do impose quite stringent duties on the parties, particularly to cooperate and to assist the court, Court of Protection Rule 1.4, and there are cost sanctions if you don't. It's also worth being aware that any welfare case in the Court of Protection does have a pre-issue stage, which you'll find in Practice Direction 3B. And it's important to make sure that you've complied with that in anything other than a really urgent case. So, do make use of those. Almost finally, what might the court do? Well, these are the sorts of orders that courts have made in cases where there's been a housing element. If the court is satisfied that P lacks capacity and it's in their best interests, authorising inspections of property, authorising a programme to declutter or remove hazardous items, authorise the disposal of items that have been removed, authorise a programme of repairs, and authorise a move by P for all this to happen if that's necessary. So those are the sorts of decisions you might find you're asking the court to make. And then the last slide has just got some free resources where you can find free statutory material or get updates, which I hope will be useful. So that's all from me. I'm sorry I've rather overrun my time. I'm very happy to answer any questions now, or we can leave those till the end. So Dan, over to you to tell me whether there's anything that anyone wants to ask.
Thanks, Sophie. There's one question that's come through for you on the chat, which might be worth answering now, because I think it's a relatively short point. This is from Diana Lilly saying, is it necessary for social workers to show medical evidence in their mental capacity assessments that a client has a disturbance of the functioning of the mind in relation to applications to the Court of Protection for the local authority to manage the client's finances where the client lacks capacity to do so?
No, it isn't. You would be asked to provide evidence from a registered medical practitioner if you're making an application to authorise a deprivation of liberty. But you can provide, social workers can complete the form COP3, which is the assessment of capacity. So you don't necessarily need to get a letter from a GP, but you would need to be able to explain what the person's diagnosis is. And then you'd need to show, can they make the decision? Is the reason that they can't make the decision because of their impairment, stroke, disturbance?
Thanks, Sophie. I think that's everything that we've had come through so far, except a question about whether the slides will be sent out to the delegates. I can answer that one myself now. They will be sent out after the session. So with that, I think we'll move now to Marie, and then we can come back to a more general discussion with questions for both speakers at the end.
Sure. Thanks.
All right, thanks, Dan. Thanks, Sophie. I'm going to be covering the more practical aspects of what to do once the issue of capacity comes up, and also particularly looking at right at the start of a case, what you should be looking out for to make sure that capacity is raised at the earliest stage that it can be raised. I'm hoping that everybody's received an article that Dan wrote for LAG, Legal Action Magazine, which I think should have been sent to you yesterday, which will go through the points that I'm going to raise very briefly in my slides in quite a bit of detail and with all the appropriate case law cited. I'm going to try and go through this quite quickly so that we can get through questions at the end. But Dan's article is really helpful if you need to go through things in more detail, and you can always feel free to email anybody here, but especially me, if you have any questions. So here's an overview of what I'm going to be talking about. So the first is a very basic sort of a refresher, I expect for most of you, of part 21. And then I'm going to be looking at sort of stage by stage what you can do when the issue of capacity is raised. So first of all, identifying the issue, how to raise the issue. So that's, either before the first hearing or at the first hearing, or as has happened to me the day before the trial. Oops, sorry, Ray, I think my slides have gone backwards. Thank you. Yep, so raising the issue when the issue arises, the procedural steps that you should be taking, how to deal with experts, and what to do in the situation where you may have a client who is refusing to be assessed. Next slide, please. So here are the relevant parts of part 21. The first thing to remember is that a person who lacks capacity is a protected party, and they'll need a litigation friend to act on their behalf. No party can take any step in any proceedings involving a protected party without the permission of the court until a litigation friend is appointed, except for issuing or serving a claim form, or obviously applying for the appointment of a litigation friend if need be. If a party loses capacity during the proceedings, no party may take any further steps without the permission of the court until a litigation friend is appointed. And finally, and importantly, any steps taken whilst the protected party does not have a litigation friend will have no effect. So I think that last point is very useful to raise if you are in a position in court where the opponent may think that you're just being purposefully obstructive and trying to create delays, which unfortunately often happens. In housing cases, when you raise the issue, the point is it is much more practical for everybody if the issue could be ironed out right at the early stages, because anything that the court does, if it later turns out that a client lacks capacity, will have no effect. It can be regularized, but surely it's better to get this issue sorted out right at the start. Next slide, please, Ray. So the first step is to identify when capacity may be an issue, and it sometimes may not be that obvious. So I have a quote here from a case of RP in Nottingham City Council, which says, once a legal advisor reasonably entertains a doubt about a client's capacity to give proper instructions, it is that advisor's professional duty to satisfy him or herself that the client has or does not have the capacity to give instructions. So I think that's really important, because the question here is about whether they reasonably entertain the doubt. So that goes back to what Sophie was saying previously about sometimes there is a slight over-reliance on the presumption of capacity, especially when you've just met a client, or you're at your first hearing, or you're at the duty desk maybe, and you've just met the client there, where you have reasonable doubts about whether that person has capacity. There is a duty on you and also on other parties to look into that and to properly investigate that, to make sure that you can be getting instructions properly. So here are just a list of bullet points of what you can be looking out for when you meet a client for the first time that may flag to you that this might be a problem. Sometimes it may seem really obvious, but oftentimes it goes past you. Just the basic nature of the allegations, especially when you're looking at cases like antisocial behavior claims or injunctions. If the allegations are things like hoarding, I have had cases where people are spreading, are alleged to be doing quite unpleasant things. So spreading fecal matter around, hoarding lots of old food, things like that. They may appear to be really eloquent and intelligent, and I'm sure they are. But if you look at the actual nature of the allegations, that may be enough for you to think, even though this client is presenting quite normally, there may be something that we need to look into, because there may be times where maybe the capacity goes in and out. Similarly, verbal outbursts, risky behaviors. So by risky behaviors, I mean, either risky to other people or risky to themselves. So setting fires, things like that, things where you have to think this person is not behaving in a way that is going to keep themselves safe, and there might be a reason behind that. Obviously, look at their medical history. But so the first thing I would do if I was going to meet somebody on the duty desk and I saw that the allegations were, as I described before, quite extreme, I would ask them about their medical history and go as far back as you can, maybe go back to school, look at maybe if they went to a school for people with special educational needs. Sometimes that's where that comes up. How the client got their tenancy. So if it's a social tenancy, did they make a homelessness application? If there was a duty owed to them, why? So the council might know something that we don't. If you've got friends or family that are visiting, you can, one thing to look out for is that they're answering all the questions on behalf of the client. And that might just be because they're a bit overbearing. But I think oftentimes, because it's so easy to get answers out of somebody who's nearby, who knows the client very well, you can kind of bypass the client. But it's important to bear in mind that maybe because the client can't answer. One thing I used to do, which is really useful, is to try and ask the client in a way that is as least condescending as possible to repeat back my advice. or really helpfully paraphrase it. So sometimes people are able to repeat back advice to you almost like a robot, because they remembered it, but they don't really understand it. So it's really useful to ask them in a way that is, again, as polite as possible, to repeat things back to you in different language, in simpler language, to see whether it's really sunk in. And I would do that at the start of the meeting, and then maybe, at the end of a really grueling 2-hour session. Some people won't remember anything anyways, because it's been so horrible for 2 hours, but all the same, at the end of it, ask the same quite simple questions, and you'd be surprised. Oftentimes they have no recollection at all of what you were talking about, and quite a bit of depth at the start. Another important one is a lack of insight into their own behavior or their mental health. So if people, I've had very, very many clients who have a very, very long history of being in and out of the mental health services, but dispute every diagnosis they've ever had. That's something to look out for if you think they may not be. There's very good reason to dispute your own diagnoses, but it's something to look out for if they don't accept that anything's wrong at all. And also an inability to give full responses to the allegations. Oftentimes when we're drafting defenses, people think it's often good enough to just deny it. It's not. You're meant to give your own version of events. So if they are just giving a blanket denial to 20 allegations, that's something to look out for. And the issue of fluctuating capacity. So even once you've had this initial meeting with them, and you may have satisfied yourself that you think they probably do have capacity, if it's a question to you, then keep it in mind. And every time you meet them, have a think about whether they are still in that position they were when you first met them. Sorry, Ray, next slide, please. What do you do once you've actually identified that there may be a problem? So the important thing to remember is that the duty to raise any doubts about capacity arises from the duty to the court. And I say that because that is something, again, that opponents should be reminded. It is not just a duty that applies to you if you have a client that you think lacks capacity. It's also a duty that applies to an opponent, even if the protected party or the possible protected party is a litigant in person. It should be raised to the court and investigated. And once the issue has been raised, the court should investigate it at the first convenient opportunity. So again, that goes back to the point of how to go about things in the most practical way. If you don't investigate it at the start and the court makes a series of directions which are complied with, and you get very close to a trial, or you even go past that point and you get a judgment, and then it later arises that the client lacks capacity, then everything is effectively void. So it really should be assessed right at the start, even if it's not particularly convenient for the opposing party or for yourselves. It becomes rather more complicated where the client themselves dispute that they lack capacity. If that is a problem, then the court is going to have to determine the question themselves. It doesn't mean that you can't raise it. You still have to raise it, but it may be that the court will have to determine that issue with or without your assistance. And I'll go into that in a bit more depth later on. Next slide, please. So here's what to do once you've realized that the issue is there. This is very basic indeed, but it might be a helpful refresher. If you become aware of the issue because you've dealt with the client quite sensitively the first time you've met them, and you think you're not quite sure that they have capacity and you have reasonable doubts about it, the best thing to do always is to raise that with the client's instructions, raise that as early as possible, right to the other side, try and agree an adjournment whilst the capacity is assessed. Try and get, I'd always prefer to get an independent psychiatric expert, because the issues of capacity I think are quite complex. And if you have a legal aid certificate, then it can be funded that way. But if things are very urgent, then going to a GP or any other sort of treating clinician, that's always a good move. But the best thing to do is to take no steps until that is decided. Same thing happens if you only become aware at the first hearing or at the duty desk. Speak to your opponent, try and agree an adjournment. If you're in a situation where your opponent is disputing whether the person lacks capacity or is refusing to adjourn it, it may be because they think you're being difficult, or it may be that they genuinely they feel like there's no reason to raise it because they have not made any medical inquiries themselves, which is often the case. You're in a situation where you're effectively without instructions, so you have to deal with it very carefully and disclose as little information as you can. Oftentimes the court should bear in mind that you have duties to the court, and that you would only be raising this if you had reasonable doubts about it, so they should give you some credit. But again, it may be useful to say to the court, look at the nature of the allegations. There may be witness evidence already on there from the landlord, which discloses some medical history of mental health problems. And in that way, try and explain why you have reasonable doubts about this person's capacity without giving away too much information that you don't have instructions to give away. Oh, sorry, Ray, if we could go back. If your client disputes capacity, you may be in a position where you have to make an application for an ex parte hearing to determine the issue. So the issue isn't really one that involves your opponent, though your opponent may disagree with you, but it is an issue between yourself and the court, or your client and the court. So the way forward that we've found in the past is if a client really does dispute whether they have capacity, especially after you have an expert report that says that they don't have capacity, what has worked with some success is to apply to the court for a private hearing, where you may not make submissions, or you may not make a positive case either way, but you are there to assist the court and give perhaps a sort of a skeleton argument, maybe, just to assist the court about what the legal framework is when deciding on whether someone has litigation capacity, and to be able to answer questions that the court may have, but again, without putting a case either way, just there to be helpful. Next step, please. If everybody is satisfied that a person lacks capacity, you don't necessarily need to make an application to appoint a litigation friend. All you need to do is file a certificate of suitability. So that's CPR 21.5 sets out the steps there. It's italicized filed because you do not need to serve it, and I'll explain that a bit later on. If you have any expert evidence in support of your decision that a person lacks capacity, then again, that should be filed and not necessarily served. The practice direction doesn't say that either of those things needs to be filed, and I think that's significant. The point again is that at that point, before the litigation friend is appointed, you don't really have a client who's able to give you instructions about what they are willing to disclose. And evidence and support, especially evidence and support of any sort of decision you've made about capacity, may affect the client, may be adverse to their interests. So you have to be very careful about disclosing that to the opposing side or any other party in the proceedings. If you are making an application to appoint a litigation friend, which I think you often will need to do if your client is disputing capacity, then that it needs to be served on the protected party, but it need not be served on the opponent again. So you just need to be very careful. And oftentimes your opponent will be very adamant that that information needs to be served on them. But the point is the court is going to be making a finding about capacity. It is effectively a procedural issue. It's not there to frustrate the court or to frustrate the proceedings. Once a litigation friend is appointed, then the claim should proceed as normal. So it is, in effect, not their concern. Next slide, please. This is the position as regards experts. So oftentimes, because all the parties are trying to get the proceedings dealt with as quickly as possible, there is a suggestion that, especially with litigation capacity, somebody who's not a medical expert, but who knows the client quite well, or is a professional, oftentimes a social worker, is able to complete the capacity assessment. This case, Masterman, Lister and Brutton suggests that that's not a good approach. So here it says, even where the issue does not seem to be contentious, a district judge who is responsible for case management will almost certainly require the assistance of a medical report, before being able to be satisfied that incapacity exists. And I think after having heard Sophie go through the law of mental capacity, it's clear that this is quite a sensitive and delicate and quite complex issue legally, and is something that an expert really should be commenting on rather than somebody who might not have medical experience. when you're drafting a letter to an expert, I think it's really important, especially when you're bearing in mind that they're only seeing the client for maybe half an hour or an hour, and they've not had any sort of familiarity with them before, and may not have had the time when you're dealing in really tight timescales to go through the medical records as in as much detail as they may like. These are quite useful things to flag in a letter to your expert. So just in outline what interactions you've had with your client that have caused you to query their capacity, what a client would need to be able to do in order to conduct proceedings, because sometimes an expert may be an expert in medicine, but they may not understand what's needed in a housing case. So here are some examples: give clear instructions, understand advice, consider legal advice, apply it, and give an alternative version of events, as I've said before, and importantly, be able to give evidence in a cogent way. If you can supply the GP records in time, then please do, and try and flag anything that you've seen in the GP records, which again is suggested that a person may lack capacity, or that they may have lacked capacity in the past. And to flag to the expert maybe that, on one appointment you thought that they were quite cogent and they understood everything you were saying, but in a later appointment maybe you felt that they didn't understand, so that might be an issue. And if you're dealing with more complex issues, I think it's always useful to flag and include elements from case law that you think are useful without obviously stacking the expert the letter of instruction too much. But one thing that I think is really useful to flag is something from a case called RERGS, and the citation is there, which is that a client may have the ability to understand the relevant information, but they may lack the ability to weigh that information up and apply it rationally when making a decision because of a mental impairment. So I think that's really important when you're thinking about people with sort of compulsive disorders like OCD, or hoarding as a standalone disorder, because again, they may be extremely intelligent people, very eloquent people. They may understand rationally what they can and can't do, and when the consequences of doing what they're doing may be dangerous. They may understand that. So to some experts who don't have this flag to them, they may think that person does clearly have capacity. But the point is they can't weigh that information up. They can't apply it because they have this compulsive disorder, which means it's just impossible to make a rational decision. Next slide, please. Here's what to do if as often happens, particularly with clients who lack insight again into their own mental health conditions, perhaps, what to do where they refuse to be assessed. Quite clearly, you can't force a person to be assessed. You can't force them to go to an expert. But the first thing you should do is you should try to explain to them why an assessment is needed and what the consequences of the failure to be assessed would be. I think a really important thing to flag to clients right at the start, because it is a really sensitive issue to have to raise to your own client that they may not understand what's going on, is to say you're not making a comment on their intelligence or their rationality, but it's really important that there's somebody there who's able to make decisions in their best interests. And you should also make clear to them, it doesn't mean that they're completely excluded from the process once a litigation friend is appointed. They can still be involved and that have their wishes considered, but at the moment, another person needs to be there to make the decisions in their best interests. And sometimes they come around after you've explained to them that it is only in relation to these very specific issues. So in a housing case, especially when you're talking about litigation, we're only talking about their capacity to conduct these proceedings. Outside of that, they should be relatively unaffected. And it's just to make sure that the landlord and the court bears all of their conditions in mind. Oftentimes, even if you make that very heartfelt plea, a client will still refuse to be assessed. It's just the nature of these things. Where an assessment is impossible for that reason, there have been cases where that in itself, that refusal to be assessed, can stand as evidence of a lack of capacity, at least on an interim basis, until a full assessment can be obtained. In those cases, the guidance suggests that the court should take a practical approach So that could include perhaps going to a treating clinician, and even if the client refuses to be interviewed, the treating clinician can comment on their previous experience of their client to the extent that they feel able. And that might be able, the court might be able to make a sort of a decent finding of capacity on that basis. And where even that is impossible, it may be possible for the court to ask for the assistance of the official solicitor to make their own investigations. The official solicitor is, of course, well placed to make these sorts of investigations in a way that a GP or a social worker may not be able to. I think that is the last of my slides. There we are, on for questions.
Thanks very much, Marie. In relation to questions, I'm going to, I think there's a couple that have come through on the chat rather than the Q&A, so I'll deal with those first and then move to the Q&A just to make sure that I don't inadvertently miss any out. The first one that we've had through is saying if capacity is time specific, in the situation of a person with learning difficulty, how long is acceptable to support someone to understand the information presented if shown that they have the capacity to make an informed decision over a long period of time? I imagine that Sophie might be best placed on it.
Yes, I mean, that's such a difficult one, isn't it? Because obviously neither the Mental Capacity Act or the code sort of say, you know, how long do you have to be able to make the decision. There's quite an interesting case called Re-C, about a young woman who was being assessed to see whether she had capacity to use the internet and social media. And the court found that, you know, the amount of prompting and help that she needed made it just unrealistic to suggest that she really had capacity. And so I think you've got to kind of look to, you know, are you at a stage where really the person is not making their decision? You know, they are having to have so much prompting that it's just not a genuine operation of their autonomy. So that I hope that helps. I think it is difficult, and it's about trying to find the right balance.
Thanks, Sophie. The other question that we've had through on the chat is about where a party is found to lack litigation capacity, and then the conditions deteriorated further to the extent that there's concerns about capacity to manage a tenancy in possession proceedings. What steps could be taken to establish whether that's in fact the case? Would you seek directions for an expert from the court in your proceedings or make a separate application to COP? I mean, it seems to me, probably kind of offering my own view first, that's going to depend on the particular proceedings, that it's going to depend on whether capacity to manage a tenancy can be said to be a direct issue in the possession proceedings. If so, you might get an expert report in that context. If not, you would have to go to the COP. In any event, it might be, given the way that the COP works and is able to be more exploratory in terms of these issues, it might be a better forum for resolving these issues than a kind of than the more hard-edged nature of civil proceedings. But I don't know if either of you have anything to add on that.
I think I'd agree with that, actually.
I think I've had this come up recently. If you in a housing case, in the housing context, so it was obviously very relevant whether the person was able to manage their tenancy, and the way we dealt with it, which I think was useful to help the court to realise that it was an issue that needed to be dealt with by the Court of Protection, is to get the expert to comment on whether they thought the person had capacity to deal with to manage their tenancy, and then use that report to make an application to the court to stay the proceedings whilst an application to the Court of Protection is made. The Court of Protection might not pay any attention to that report, and they might get their own report that might be more useful, but it's good just to give the court grounds to realise you're not, again, just being obstructive and causing delays.
And again, I suppose the question is, well, what are you asking the Court of Protection to do? Maybe it might be that you're asking them to appoint a deputy. It might be that you're, asking them to authorise the surrender of the tenancy. But again, always, just be when you possibly can, if you are putting a question to the Court of Protection, you just try and be as clear as you can about what they're actually being asked to do.
Moving then to the Q&As that we've had through, the first, I think, is really a question for Sophie, asking for views about the JB case. It says, view of JB doesn't help with learning disability and impulsivity. Any views?
Yeah, I mean, I'm not entirely sure I agree. I mean, I think it probably it does try to do that, And it tries to give, it's identifying the information that you need to be able to understand to make a decision about sexual relations. So I'm not so sure that it is that bad. I think we probably can't go much further than that this evening, but I'm happy to, even if you wanted to email me and tell me specifically what you've got in mind, I'll happily email you back.
Thanks, Sophie. We've then got a question that's fairly detailed and about the position of professional trustee, and where there's a denial of knowledge of a beneficiary lacking capacity. I think that probably ventures more into estates law and the facts of this particular case than we're going to be able to deal with helpfully tonight. So I hope I'll be forgiven by the questioner for moving over that one. We've got another one saying, can a solicitor assessments be done again? I'm not sure I know immediately what that question's getting at. I don't know if whoever's asked that could perhaps provide some clarification in the Q&A, and if we don't get time to get to it, send a direct email in. The next one says, how would you advise dealing with a situation where a defendant who's refused to attend several ASB court hearings and then has a litigation friend appointed is ordered to be assessed by the court but refuses to engage? The assessment's therefore produced by way of a desktop assessment using old information and the input of the litigation friend. Defendant lives alone and manages their own bills and property as a tenant. Says that they don't recognise the authority of the court and only God can judge. Previously diagnosed with paranoid schizophrenia, but released from a community treatment order by an application of the litigation friend 4 years ago. I don't know whether either of you have any comments. It's quite a detailed set of facts, and again, it may be that the answer is that it depends what the assessment says and where you go from there on the facts. But I'll hand that over in case anybody has any thoughts.
I mean, again, yes, I think that's right. And sort of, what I mean, the problem arises, doesn't it? If you've got someone who lacks capacity, are you in a situation where they can't be bound? Can they be bound by orders that they don't have capacity to comply with? I mean, again, I think I would be saying, well, what are you trying to achieve? Are you saying that they can't manage their bills? Do they need consideration of a deputy being appointed? Are there issues about whether they're actually living in the right place and whether they have capacity to decide where to live? I mean, as Marie is saying, desktop assessments can sometimes be made if the person absolutely refuses to cooperate and there's no other way of getting any kind of an assessment.
Yeah, I agree with everybody else. Again, it will depend on whether what you're actually assessing. So if it's litigation capacity, then as Sophie says, it might be able to, the refusal to engage with the proceedings at all might themselves stand as evidence that that person lack, or very indicative that the person lacks capacity. And similarly, if it's an ASB issue, if it's a question of whether they can comply with an injunction, if that's what the opponent is looking for, or even whether they can comply with an SPO, if that's made, then I think their complete refusal to engage with the proceedings may, though if it's a possession claim, this may be adverse to them, so be careful, but may again stand to suggest that they lack the capacity to comply with any order the court makes. So if it's an injunction proceedings, that I think I would argue that it wouldn't be just and equitable to make an order in those circumstances. But if it's possession proceedings, you need to be a bit more careful.
Thanks both. There's just a few more. I can see that we're now at 7 o'clock. If you were both able to stay for a couple of minutes, I'll try and skim through the final questions relatively quickly. There's one person who's asked about whether anybody can recommend experts in assessing capacity who understand Mental Capacity Act, Care Act, Mental Health Act. I think probably that will have to go to other forums. I don't think we're able to start on recommendations now. Certainly haven't come with a list, so I'm afraid, at the risk of dodging too many, I'm going to skip over that one. We've got somebody with a question for Sophie. You gave the example of eating disorder where fear of food was the overriding factor in decision making. Could this be applied to cases of domestic abuse, or where coercive control may be involved, even if not disclosed, so fear of the perpetrator will be the overriding factor?
Yeah, that's a really good question. I mean, in relation to the woman with anorexia, it all goes back to the causative nexus. What is the role that the disorder or the impairment plays in influencing that person's thinking? because this young woman had anorexia, that was the driving factor that made her so fearful of food and calories. And I'm not sure that that is really, if you're talking about sort of a fear of a perpetrator who is visiting abuse on you, I'm not sure that that's necessary. That doesn't seem to be related to the impairment or disturbance. There is some very interesting and important case law in the high courts, in the inherent jurisdiction of the high court, about the role of coercive behaviour in overwhelming people and preventing them from exercising their capacity. And there have been a couple of court protection cases about coercive control, vitiating people's, preventing people from exercising their capacity. But there does have to be that disturbance or impairment for a finding of lack of capacity.
Thanks, Sophie. There's just two more that I think it looks like one for each of you, actually. First, a relatively quick one for Sophie. Are speech and language therapists considered medical experts, given that then the nature of their role is to support that person's specific communication needs and assess understanding of language and retention of information? I don't know whether there's any case law that you're aware of on that or not.
On capacity, I am not sure that I think that they may be. I'm not sure that I've had a capacity assessment carried out by a speech and language therapist. I've often had speech and language therapists being asked to do reports to look at communication and to advise about enhancing communication with a view to helping a person make a decision if their capacity is borderline.
Excellent. And finally then for Marie, although Sophie, if you've got any thoughts as well, somebody saying it can sometimes be that what really puts P off from engaging is when you have to tell them that while a litigation friend needs to give serious consideration to their wishes and feelings, they won't necessarily follow them. Do you have any suggestions about how to manage that scenario?
It's extremely difficult is the answer. I think that is the crux of it, is they're right. Their wishes and feelings need to be borne in mind, but they're not necessarily going to be followed. I think what you need to make clear to them as sensitively as possible is that the issue has now been raised, and you're going to be in a very difficult position if it's not determined. So the outcome of them refusing to be assessed is not that there will be no assessment and everyone's going to assume that they have capacity and everyone's happy and they'll still be able to make decisions. Is that now there's a very difficult question in front of the court about whether they have capacity or not. The court isn't in a position to proceed until that is resolved, and you're not in a position to take instructions from them until it is resolved. And also the court's not going to be in limbo forever, so a determination is going to be made. And the best thing for them is for them to see an expert, and the expert is best placed to make a decision. So I suppose one way of saying it is to say, either you go see the expert and you're able to talk to them for an hour and give your side of it and explain why you think that you have capacity, whereas otherwise the court's going to have to make a decision based on the information they have in front of them, which may be suggestive that you don't have capacity. So I don't know how to put that in a way that isn't threatening. There's nice ways to put that, but I think that might be the argument you use.
Yeah, I completely agree. I think that's absolutely right.
Well, thank you very much first to everybody for attending and for some very interesting and helpful questions. And also, this is the point where I'd ask you to join me in a round of applause for Sophie and Marie, but with you all on Zoom, it would just be me clapping, which might be a bit embarrassing. So I'd like to pass my thanks, and I'm sure yours also, to both of them for very interesting and helpful presentations. Thanks very much, everybody.
Thank you very much.
Thanks, Dan. Thanks, everyone, for coming.
Yeah, it's great to speak to you all.